Hi, my name is Rosaria. My ideal student is 692. In here, I will analyze the banking law perspective in Garuda, Indonesia. My discussion will cover the bank financing the credit scheme used by Garuda, Indonesia, the legality trump rent banking principle, and the role of the bank in the debt restructuring process under Indonesian law. The first one is background of Garuda, Indonesia, financial banking issues. Garuda Indonesia, the nation flag carrier of Indonesia, faced a severe financial crisis after the COVID-19 pandemic that drastically reduced passenger demand and cash flow. By mid-2022, the airline recorded total liability reaching approximately 142 trillion, owing to more than 5,000 creditors, including aircraft leasing vendors and banks. Among the creditors, there are three state-owned Bank Mandiri, Beni, and Beri were significant bank creditors with combined export of around 11 trillion in the debt owned by Garuda Indonesia. The second one is financial and credit scheme used by Garuda Indonesia. To support and operation the investment activity before the crisis, Garuda Indonesia relied to various bank financial schemes, including the working capital loan to support daily operation, investment loan for aircraft acquisition and related capital expenditure. Aircraft leasing the financial partly structured through the banking intermediaries. However, with the cash flow that do not rapidly during the pandemic, Garuda was unable via the scheduling the pay to bank, leading of the inclusion of the formal structure proceeding. The third one is legality of collateral and prudent bank principle from the bank law perspective. The issue of the credit by Bank of Garuda must comply with the Indonesia prudential banking principle as regulated by Financial Service Authority, or you call it OJK. They included the careful assignment of the repayment capacity of debtor, the value of legality of collector platinum, and the sustainable of the debtor business model. In order to avoid excess practice, the in Garuda case, fixed asset must lien abolition. We are also use a collector and short and long-term bank loan. The mostly we combine with the requirement of a legitimate and enforceable security insert. The next one is the role of the bank in Garuda Indonesia debt recruiting. With the Garuda Financial Distracting, Invest5 Bank averted immediate enforcement addiction for collaterate seizure in standard option of credit recruitment measures. They consistent with prudent bank practice and under the supervision Indonesia Code. There's a restructuring strategy that included the restructuring low tenor, postponed principal repayment, and adjustment in interest term, with Apollo's aim to establish the Garuda finance with giving the company a structured plan towards recording. Additionally, many creditors, including bank, participate the burden of PKPU perspective of the bad payment obligation, with the process which a majority of creditors approve a composition plan to organize more than use 5 billion of liability. The second one is the impact erosion of Garuda the banking sector. The debt recruiting had a measurable positive impact of Garuda liquidity and continued to operation. It allowed with the airline to avoid liquidity with maintaining the old business presence of Indonesia aviation market. For a brand implementation recruiting and according with banking standard helping mitigate the credit risks and avoid the system stress financial sector perspective enforcement could have a trickle burden financial imputation. In conclusion, for the banking and law perspective, in the case of Garuda Indonesia, illustration how bank play strategic dual role, not only the expected credit but also facility legal combination and prudent debate direct routine under Indonesian law. The conclusion, my explanation for the part A, banking law analysis. Thank you.
Okay, I am Nabila Mutiara Putri with number NIM 343. And now I will explain part B of our analysis, which focus on the PKPU process and the restructuring in the case of Garuda Indonesia. I'll discuss the legal basis of PKPU and then how the process unfolded, also the impact for both the company and its creditors. First one, let's talk about what is PKPU. In Indonesian law, PKPU is stands for Penundaan Kewajiban Pembayaran Utang or Postponement of Debt Payment Obligation. Okay, PKPU is a legal instrument under law number 37 of 2004 regarding bank korupsi and PKPU, designed to give a troubled debtor the opportunity to give temporarily delayed debt payments while preparing a peace plan with creditors, supervised by the commercial court. And this process is meant to be a win-win solution where both debtors and creditors can negotiate terms that help the company continue operating and maximize recovery for creditors. Okay, the second one I'm going to talk about why Garuda choose PKPU. Garuda Indonesia, like many airlines affected by the COVID-19 pandemic, okay, they faced the overwhelming financial pressure and was unable to meet its debt obligations, okay. The airline's total debt before restructuring was roughly around 138 until 142 trillion rupiah, owed to the hundreds of creditors including banks and aircraft lessors. Rather than face liquidation, Garuda filed for PKPU in late 2021, which was then confirmed by the commercial court after creditor cooperation and requests from both parties. This allowed Garuda a legal framework under which it could propose a composition plan for restructuring. Okay, next, the third one, I'm going to talk about the PKPU process. Once the court accepted Garuda's PKPU petition, the next step was negotiation between Garuda and its creditors, okay, including banks and lessors, under the supervision of court-appointed administrator. Creditors then vote on the peace plan, okay, and more like 95% approved the proposal at a hearing in June 2022, leading a homologation, a court's ratification of the agreement. Under the plan, liabilities could be reduced by around 80% through restructuring measures, including debt conversion to equity or new bonds, and loan from state-owned banks were converted to long-term instruments with up to 22 years tenors and very low interest rates. This legally binding homologation meant all creditors, including banks, were obliged to follow the agreed plan. Next one is number 4. I'm going to talk about the role and benefit for the banks. For banks, participating in PKPU meant avoiding the loss that might occur under a normal default and keeping the debtor as a going concern. State-owned banks such as Bank Mandiri, BNI, BRI were among the major creditors and agreed restructured terms instead of enforcing collateral immediately. Under the restructured terms, banks would recover their claims over a long horizon, and this prevented their loans from becoming irrecoverable non-performing assets. Next, number 5, I'm going to talk about the impact of the PKPU on Garuda and the creditors. As the result of PKPU, Garuda could avoid bank korupsi and maintain operations while implementing the peace agreement. And creditors, including banks and lessors, had a structured path to recover parts of their claims rather than risk loss in bank korupsi. This reflects the core purpose of PKPU to preserve business continuity while balancing creditors' rights under Indonesian legal safeguards. So, in conclusion, the PKPU process in the Garuda Indonesia case demonstrates how Indonesian law provides a structured mechanism for debt restructuring, enabling a company in distress to negotiate and implement a legally binding peace plan with its creditors. And that's all for the part B. Thank you.
Hello everyone, in this part I will explain anti-monopoly and unfair business competition issue in the case of Garuda Indonesia. Number 1. Market position of Garuda Indonesia. Garuda Indonesia is the national carrier of Indonesia. Together with the subsidiary, Citylink Garuda has a strong position in the aviation market, especially on domestic and certain international routes. Because of this condition, Garuda can be considered as a company with a dominant market position. A dominant position is not illegal, but it becomes a legal problem if the company abuses its power and harm competition. Number 2, illegal ticket price cartel. Garuda Indonesia was involved in a case related to the illegal airline ticket price surcharge. Several airlines were suspected of setting ticket price together, which caused ticket price to become high. And similar in the market, this practice is known as a price fixing with the possibilities under. And Article 5 of Law No. 5 of 1999 regarding price fixing agreements. Article 11 of the Law No. 5 of 1999 regarding cartel protection. The impact of this practice includes has consumers having unlimited price choice, high ticket price, smaller airline fashion difficult to comment fairly. Number 3, the role of KPPU. The KPPU, Business Competition Supervisory Commission, plays an important role in supervising and enforcing competition law in Indonesia. In the Garuda case, KPPU investigate the airline industry, found indication of unfair competition, imposed administrative sanctions. KPPU emphasized that financial difficulty of efficiency reason cannot justify cartel behavior. Companies must still obey competition law even during a financial crisis. Number 4, impact on consumer and the economy. The airline cartel practice has a serious consequences such as increased travel costs for the public, reduced consumer welfare, disruption of national mobility, and unhealthy business environment. In the long term, this practice can damage the aviation industry and the national economy. Number 5, conclusion. Garuda Indonesia has a dominant market position. The illegal ticket price cartel violates Law No. 5 of 1999. KPPU plays a key role in protecting fair competition. Business efficiency must be observed without violating the law. Therefore, Garuda Indonesia must implement transparent pricing strategies and comply with competition law to ensure fair and healthy business practices. Thank you.
In the summary, the Garuda Indonesia case show how the law and the business intersect in a crisis. And from the banking law, the banks apply a prudent principle and help the restructure Garuda debts to keep the airline operations. Through the PKPU process, the Garuda legal reorganizing its liability with the creditor approval and annulling the bankrupt. In the term of the competitions law, the Garuda and others airlines were found to engage in the unfair pricing practices that violate the law the number 599 and the ruling by KPPU implies that suppliers can't reform that for the fair and competition even during the difficult times. Overall, the case highlight that companies must be balanced financial recovery, legal convenience, and the fair competition for a sustainable business.